Kerry, why don't you give this to Charmaine? Thanks. Hi, won't you just ask Megan for the timeline, you know, when they're going to have tea and stopping? I know they mailed something through. No, it's not. No, it's not on the list. Okay. 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 All right. Okay. Thanks. Okay, good morning, everybody. Craig, are you with me?
Morning, William. I'm here. Thank you very much.
Excellent. Morning, Barbara and all the others from LSSA. Thanks for setting up everything. Very professionally done. There were possibly some hiccups. You know, I think one thing that COVID-19 has taught many of us that may not have been as efficient as somebody like Craig Pedersen with electronic equipment is how to run a lot of things more effectively from an electronic point of view. I mean, I don't think any of us did many Zoom meetings or Microsoft Teams meetings in the past, but it actually has become part of life, and even in the court system, particularly at the Supreme Court of Appeal, it has become quite often used. But I think there are certain problems as to the efficiency of using audiovisual links in court proceedings. It's all very well doing it when you are presenting heads of argument and arguing a matter without evidence being led, but it does become a bit difficult when one has to deal with cross-examination of a particular witness. But we can all discuss that a bit later. Welcome everybody else. This obviously is the first year that these seminars are being run by way of a webinar, and you know, it's great. I see there are quite a few delegates. Often it's you know, better to engage face on face, but hopefully next year, with COVID being sorted out, although it seems things are back sorted and suddenly it comes back again, that we can have a, you know, face-on-face seminars where it's sometimes better engaging with people. I found, you know, a lot of questions are asked after the seminar, and you meet up with a lot of people, even when you are back at home, as it were. In the past, I've received a lot of queries, and people have often asked me for information about cases that they are doing. So I think from that perspective, it's extremely exciting that one has this link up afterwards. Just some housekeeping rules. I presume those have been sent to the delegates. That is, obviously, you keep your video off. I mean, the other day I was doing a Microsoft Teams webinar for candidate attorneys in the Western Cape, and all I saw was one candidate attorney sitting on the couch throughout the hour and a half webinar, smoking. I'm not sure if he picked up much, but one, just please keep the cameras off, and you know, there are going to be breaks as we go along. I think the first session was supposed to be from 10 to 11, and there was a break, so-called smoke break for those that smoke, from 11 to 11:15, and then session 2, 11:15 to 12:15, and then questions answers from 12:15 to 12:30. So that may change a bit because we've just been a bit late in starting. So we'll just sort of take it as it comes. I'm not sure if all the delegates have received the slides. So those were supposed to be emailed to everybody. But so hopefully everybody has sight of the slides in advance. In other words, making up the bundle of the documents that we're going to be looking at today. And obviously the time is a lot shorter. Normally these seminars are run from about 9 o'clock till 4 o'clock in the afternoon with a break for lunch. But obviously we are a little bit tighter now with regard to the with time. There is another one tomorrow, but for today, one may not deal with some of the items as in detail as it is hoped. But if one has access to the slides with all the documents, looking at the various topics, then in fact that extra information is then available to everybody. So the various topics that we are going to deal with, we're going to start in fact with forensic evidence, because we have Craig Pedersen, who's a forensic expert, who's going to share the first slot. So I thought we'd start with that. We're going to deal with admission of guilt fines. I think those have become particularly prominent during the period of lockdown. Then bail applications, including bail appeals, the whole issue of cannabis, and how the new bill is going to affect the use and cultivation of cannabis after the Prince judgment, which started in the Western Cape High Court and then ended up in the Constitutional Court. And as a result of that, the bill has, has presented itself. It needs to be looked at in great detail, but we're not going to do that today, but we're just going to basically touch on that. Search and seizure, in other words, when the police arrive at your home or your client's home with or without a warrant, what to expect and how to deal with those search and seizure procedures. They've become commonplace these days. And then as well, Section 252A trap operations, where the police get information and the requirements that are needed before the police go and entrap somebody, let's say dealing in drugs or some other kind of illegal activity. All right, that then briefly dealing with the agenda as we go, and then obviously at the end we're going to have questions and answers. But I think what we're going to do with regard to questions and answers is start with our forensic slot, and that you possibly then we can deal with questions and answers, let's say for 5 or 10 minutes, so that you don't have to stay in on the whole seminar, unless you'd like to, and we leave it to the end. But we did discuss this earlier, so maybe we can do that after your forensic slot. Are you okay with that?
That's super. Thanks very much, William.
Right. So just a brief introduction about myself. I'm a legal practitioner and out of Cape Town, specializing mainly in criminal defense, except these days with COVID, and there's been a sort of a slowdown in a lot of work. I think many criminal defense lawyers are kind of looking at broadening their spectrum, but I from my angle, have seen a lot more criminal cases coming in during COVID, and even now after COVID, there seems to be a lot of crime. So whether that's a good or bad thing, it certainly does make work for criminal defense lawyers. I serve as chair of the Law Society of South Africa Criminal Law Committee, as deputy chair of the Legal Aid Committee. Previously, I was chair and Law Society, and also a councillor at the Law Society of South Africa. So that in brief, my sort of to the point CV. Craig, maybe you can just give us a short rundown on your credentials before we start on the forensic side of the chat today.
Sure, thanks, William. I'm a forensic investigator by trade. I'm also a certified fraud examiner and a certified cybercrime investigator. So much of my time in the last 10 years plus has been spent in and around the digital forensics field, working with drive analysis, acquisition phase, execution of anti-pillar orders, and also obviously data analysis of the retrieved data and preparation for presentation to court of those artifacts. Effectively, I'm 90% geek and 10% investigator. Combine the two together and you end up with a forensic investigator.
Great, thanks, Craig. So I think we're going to start with you, Craig, but if I can just give a bit of a sort of intro relating to forensic evidence. I think forensic evidence these days has become far, far more important than it was, let's say, 10 or 15 years ago. I think we all have cases these days which are possibly 90% based on forensics. In other words, your fingerprints, your DNA, blood spatter samples, cell phone records, tracking of people. And it is often that you have a case which is based wholly and solely on, let's say, CCTV footage. And obviously, what has to be looked at is how the footage, for example, is secured and the chain of evidence up to the time it's presented in court. So years ago, you'd have eyewitnesses. There often aren't eyewitnesses these days because some of the offenses that are committed are actually planned. So the criminals try and commit crime to avoid being detected and to avoid witnesses being present. But as we've seen recently, there's been a significant improvement with the police and the investigating techniques with regard to cell phone tracking, and also with regard, even if one goes on to commercial cases, where often the police have to access bank records and have to make use of Section 205 of the Criminal Procedure Act to be able to access bank records to trace the money line. Somebody works for somebody else and steals money, and they can then access that other person's bank account under order from court, obviously, to be able to find the trail of the money from where he worked or she worked up to where that money was invested in that person's particular account. So I think it is very important for all legal practitioners. It doesn't matter in which court, but to be able to be au fait with forensic evidence. You need to go and read up more about DNA. You need to prepare when you are about to cross-examine an expert by possibly engaging your own expert. Now, this can all cost money. Craig will obviously tell you that to engage an expert costs money, but you can also try and speak to an expert to try and prepare for cross-examination. You don't have to have that necessarily that witness come and testify in court. So many cases from your simplest charges, let's say driving under the influence of alcohol, blood alcohol over the limit, even speeding cases, it becomes quite technical. For example, those that travel up the N1 from Cape Town to Johannesburg, or the other way around, by car, not so much in the past, most of us fly, would have seen average speed tracks along that road. Now, I've recently had 2 or 3 cases where people have been caught speeding in terms of the average speed system along the stretch of the road, particularly in and around Lanesburg, in the Karoo, in the Cape. Now, I've had to engage experts there to test the correctness and reliability of that trapping system. And what has actually come from that is that that trapping system is not reliable at all. So in your most simple case of a speeding fine, and why it's important to contest these speeding fines, in some instances, the person gets arrested and gets detained, and if he is convicted, from that will follow a criminal record. So we'll discuss that a bit later with regard to the admission of guilt fines. But that's why it's important to know the law and why it's important to be able to engage an expert who can assist you with regard to how to challenge. Because, you know, at university, you probably did a quarter course in forensics. Unfortunately, not enough is taught about forensics during university. I think it's very important that it becomes a major course linked not only to criminal law, but obviously even civil law. It's important to know things like forensic auditing, you know, your DNA, your cell phone situation, bank account accessibility, what can be accessed, what cannot be accessed. And that is why forensic evidence plays such a significant role these days, not only in the criminal justice system, but I think in all aspects of law. Craig, maybe you can just take us through, we'll start with you, take us through what you do and how you view the importance of forensic analysis and what you are often asked to do and to assist lawyers, whoever requires your services, but particularly lawyers, and where that evidence can be presented in court and where you may have to go and testify later with regard to aspects. So can you, I think, lead us into that it's a very tricky field and confusing, but we all can learn and pick up and read about it and Google about it. Sometimes you get the wrong information if you Google too much, and you need to know who to speak to. I can say I often used to call David Klatzer. He's a forensic scientist. Now, unfortunately, he's emigrated to the United Kingdom. I still am using him in a case at the moment. But where he was so amazing was you'd phone him and say, David, give me somebody who can tell me about fingerprints. Who's the best person? And he'd be able to give, although he wasn't a fingerprints expert, he could give you the name and he could give you the best person for the job. His expertise lay obviously in forensic science, but particularly with regard to ballistics. In other words, relating to firearms, and many cases also these days deal with ballistic evidence. And maybe that's the only evidence linking somebody to a particular offense. In other words, his firearm is found somewhere, or the shell from his firearm is found close to the crime scene, linking the firearm, and then obviously linking the owner of the firearm. Okay, Craig, thanks. And thank you very much for making yourself available.
No, thank you, William. Okay, a lot of my day-to-day work is actually with attorneys, both criminal and civil. And sometimes it can start with something relatively simple. A seemingly anonymous post that's made on social media where the attorney concerned wants to get behind who's the actual beneficial owner of that profile in order to serve process on them. That would be a very small and minor part of it. It's still a forensic task, and that there's a lot of digital evidence that we can follow to try and isolate who owns that profile. We're often asked to look at cell phone records, the way that they're analyzed, the structure of the records, to see whether they've been modified in any way. And one of the things I want to discuss in today's session is been a recurring theme through the last year, and that is the admissibility of WhatsApp messages, how they should be admitted to court, can they be tampered with, what can you do with them, and what is the correct way in order to extract those records for either civil or criminal proceeding. Because there's so much happening on WhatsApp these days, from people receiving anonymous threats through to business transactions that are negotiated and structured over WhatsApp, but then later fall through the cracks, and the parties want to revert back to the agreed conversation. It can be quite a minefield in terms of extracting the evidence and presenting it correctly. So I think what I want to do is I'm going to start a screen share and take you through a couple of slides. And we're going to discuss a little bit around WhatsApp and forensic constraints around WhatsApp. We'll look a little bit at cellular phones, what you should and shouldn't expect and how to work with that data. And we'll look at two of the fundamental principles of the chain of custody and the way that the data is analyzed. Obviously, digital or not, it's still an exhibit, and it needs to be treated in the same way as an exhibit in order to ensure the provenance and present it before a court. So I think without further ado, I'm just going to share my desktop with you. And William, if you can just confirm that you have the first slide up, it should be a logo, a yellow screen.
Absolutely. Digital forensics.
That's it. Okay,
Yes.
so let's crack on. To start with, I'd like to dive right into one of the areas that we're often asked about in the forensic field, and that's WhatsApp. So how does it work? What are the options that exist for extracting WhatsApp information? Can you subpoena it? If you subpoena WhatsApp, how would you do that? And what would you get back? What could you expect from them? I don't think I need to take up any of your time explaining what WhatsApp is. I think that should be pretty explanatory, self-explanatory. What I am going to ask just before I go any further is, of the many challenges in life, I am extremely hard of hearing. I only have about 40% hearing, and I'm normally reliant on lip reading, which is going to be pretty damn tricky over a webcam. So if any questions do pop up, I would ask that you just park them in the chat area, and then we'll go through them at the end and we'll work through them one by one. It just kind of helps me if I can read them, and we can always ask and answer as we go. Okay, so let's get to WhatsApp. How does it actually work? Well, WhatsApp is a direct messaging service. So WhatsApp is sitting in the middle. Now, this becomes quite important to understand when you need to acquire a WhatsApp conversation in terms of what does and doesn't potentially exist. So effectively, a message is sent from the sender to the WhatsApp server. When it reaches the server, it's held intact, but only until the recipient takes delivery of the message. It's kind of like the electronic version of pass the parcel. Once a WhatsApp message is passed over to the recipient, it is no longer on the WhatsApp server. They do not store it. But the message does exist in two places. Firstly, on the sender's device, where it's stored until deleted, and on the recipient device, again, until it's deleted. These are the only two locations where the message exists. Once it's received, it no longer sits on WhatsApp. If the sender uses a delete for all option within the chat, within a few minutes of sending the message, it's actually removed from the databases on both devices. And in theory, it no longer exists on either handset. And I say in theory because it is deleted. And depending on the time span between the deletion and actually analyze on the phone, you can often recover those messages. But the time span is quite critical. Rule of thumb, I would say 5 to 7 days with average use of the device. You can still recover it. After that, maybe not so much. So this can be problematic, where the content of the message itself is needed in support of a position in court. And I'm often asked to assist with subpoenaing the information from WhatsApp. And it's important to know what is possible, and because of the way that the technology works, what are the limitations? So what is available and usable should you subpoena WhatsApp? And if you want to subpoena WhatsApp, how would you do that? Well, there are a few options to acquire information in WhatsApp, and there may or may not be information of value to be had, and we're going to look at some of that now. But before we look at the information that's available, let's just look at the mechanisms that are available to acquire the data at all. Section 205 under a MLAT. Well, Section 205, standard subpoena in a criminal matter, issued under Mutual Legal Assistance Treaty, which exists and facilitates the process, obviously, of exchanging information at a law enforcement level, provided the subpoena is appropriately structured. So in the case of WhatsApp, which is of course now owned by Facebook, so the same applies for Facebook and most other social media strands, the standard court-ordered Section 205 subpoena issued by a South African court will suffice, as long as you've set out the basis of that evidence and why it is relevant to the case, and is not going to impede on the rights or the information of parties outside of the parties within that case. The subpoena is just made out to WhatsApp and outlines the data required and the structure of the case. You need to state the case quite clearly in terms of what information is required. If you ask for too much information and your request is too broad, it will probably be declined. The golden rule is ensure that it doesn't impede on the privacy of a third party or parties outside of the conversation. And again, do bear in mind there are limits to what you're going to get. Now, the subpoena itself, once signed at court, can be served on WhatsApp electronically, which is really convenient. So via the law enforcement portal. Let's just get a snapshot of that up. Via the law enforcement portal for WhatsApp, the investigating officer can go and load the 205 documentation, and he logs into the portal, and he can then follow the process of the data request as it moves through the machinations of WhatsApp, ultimately to be returned. The investigating officer is going to have to log in using a @saps.gov.za email address. Now, I'm sure you've all worked with SAPS before, and you understand that official SAPS email addresses are a bit of a scarcity. There's generally only 2 or 3 people at a station that have access to them. If it is not served from a @saps.gov.za email address, it is not going to be accepted. WhatsApp will reject it immediately. So if the IO doesn't have an official SAPS email address, he's going to have to use the communal address at the station to facilitate the process, or ask for it to be escalated to cybercrime so that they can process it on his behalf. Once a subpoena is loaded, you can follow the process online until the data is returned. And it's highly advisable not to mark your request as urgent unless you can substantiate the urgency. Now, WhatsApp's really, really particular on this. A normal return of data takes about 2 weeks, depending on how busy they are at the time, because obviously they're processing requests from around the globe. However, exigent circumstances where a quantifiable emergency exists, such as a kidnapping, for example, subpoenas to WhatsApp can be marked as exigent in the subject line, and they will receive priority attention, usually with the return of data in 24 to 48 hours. Missing person and a kidnapping would be 2 great examples of exigent. You just need to quantify them quite carefully in the subpoena itself and the supporting documentation. So, of course, the question that remains is, if you were to subpoena WhatsApp, well, what could you expect to get back? Just a snapshot, that is Facebook law enforcement portal. Again, Facebook, WhatsApp, owned by the same entities, same sort of process, same tracking ability to each data request. So what you're seeing on the screen in front of you is a sample on the left of the amount of information available, and it is rather limited. It's not useless, but it is limited. You're not going to get conversation data. The data that you're going to get here is the last IP address used. Now, IP address, which is an internet protocol address, coupled with the exact time at which the handset used that IP address. Also, on the return of service that you can see there. That's going to be valuable information. That IP address in turn can be tracked and identified a handset as having been used on MTN in this case. On the left, it's probably a little bit indistinct, but you'll see there's an IP address and a time. And if I use a IP tracking tool and I just put in the IP address, I can see that it belongs to MTN. I can now subpoena MTN with, again, the exact time and date and the IP address, and they will be able to revert to me with the subscriber information. It could be a cell phone number that requires more investigation. It could be a subscriber name and ID number if it's actually a fixed line, an ADSL line or a fiber optic line connection. So in this case, as you can see, leads to MTN. Now, the service provider locally can then be subpoenaed on the strength of the WhatsApp return data to identify the subscriber and the cellular phone number as well as the location. So you can see on the data return and at the time of registration, the device name is also captured over here. So one can build a physical make model of the cell phone to a known suspect if indeed you have one. So when you eventually acquire the suspect, you can match, is the cell phone in the suspect's hands the one that you should be finding linked to that WhatsApp account. But overall, as you can see, the amount of data that's available from WhatsApp is very limited when you consider the time it takes to get the subpoena the data and then still further drill down into more data if you need to. So where a specific WhatsApp account, however, needs to be bound to an individual to provide positive evidence, this could well serve the purpose, and it is a viable option. In some cases, I have seen it where WhatsApp will able to also return group memberships of that account, as well as the vanity name or screen name. Vanity name, for example, my cell phone number would be my WhatsApp account number, but Paddy or Craig Pedersen would be at the top of my WhatsApp account. That would be a vanity name. If I belong to a couple of groups, it may be possible for WhatsApp to give you the group memberships and the other cell phones that are also linked into that group, and that information can be quite useful. So, bearing in mind what's available from WhatsApp via subpoena and MNET, it leads us to the question of what is available and how do we use it? Well, often one party will have copies on their handset of the WhatsApp conversation, and that conversation could have relevance in court. In order to present WhatsApp information to court in a forensically sound manner as possible, you should ideally have the handset analyzed and a dump file created. Now, I'm going to talk a bit about dump files. It's an extraction of all the data on the file, on the phone, in a way that you can read. Sometimes it's not possible though, and one has to look at alternatives that are available. So let's look at a quick example. This is a screen grab of conversation between two parties, which is now being contested. And I want to acquire the conversation in the most forensically sound manner so that it can be presented in court. Commonly, what I see quite often is people will just take screenshots of it and save the screenshots. Now, screenshots are taken directly on the device. They're a good starting point, but they tend to lose some of the metadata that we'd really want that to support their authenticity and to show that they haven't been manipulated. So as a general principle, I wouldn't want to change anything on the device I'm assessing. So I don't really want to take screenshots on that device. So I take another phone and take a photograph. That's not perfect, but it's a better option because I could present the metadata of the photos I'm taking to support when and where the photos were taken. I'd simply scroll through the conversation, take photos as I go along in the appropriate sequence. But that's not really enough. So as a second step to authenticate the conversation, I tap on the contact, scroll to the options to export chat. So if you just tap on Johnny Doe, you can scroll down the options and you'll see there's an export chat option. And that would export the chat to a file, and it gives you the options to include images or exclude images, which you can then email directly or rather download to a memory stick on the phone. So the challenge, of course, is that the output here is a straight TXT file, it's a little notepad file. And it's really, really easy to edit that file before printing. There's not a lot of provenance to a text file. So that being said, a text file supported by photos and screen would still be preferable just to standard screen grabs. So ideally, you'd want to show that the chat export and the photos were acquired by an independent party and not the owner of the cell phone to add further credence to the authenticity and completeness and to support that with a statement. In order to provide some kind of provenance to the screen photos, I'd probably include the metadata of the photos to show the when and how they were taken as well. To get to that metadata, I'd need to directly download the photos rather than WhatsApping them to myself. And that's quite important because when you're working with metadata, now metadata is data that is created about data. It tells us more about when, where, and how the file was created. When you send a photo via WhatsApp, for example, the metadata is stripped out to get the lowest possible file size and to keep consistency in the way that the image is worked with over the WhatsApp platform. So if you look on the left, you'll see a typical photograph with all the metadata intact as to who took the photo, when they took it, the GPS coordinates, the precise date and timestamp. There's a lot of useful information in there. The moment it hits the WhatsApp server, all of that data is lost. It's compressed in order to keep consistency over the WhatsApp platform. So that means if I took photos of the conversation and sent them to myself via WhatsApp, I'd lose some pretty crucial data that substantiates the when and where the photos were taken and links them back to my handset. Remember, my objective here is to provide as much clarity to the court as I can that the presented evidence of the conversation is complete and unaltered in the absence of a cell phone dub. So by using a cell phone to take photos of conversation screens, supporting it with a text-based export, and retaining the device to cross-reference, I'm starting to build provenance to that data and to show the court that it is an accurate representation of the conversation that took place. Ideally, this is also something done by a third party to retain the credibility of the process. Which brings us to the topic of acquisition. Now, in terms of acquisition, I'm not just talking about WhatsApp, I'm talking about the acquisition and acquiring any digital exhibit. And it's quite a crucial step in ensuring that that exhibit is going to be admissible in court. And you want no breaks in the chain of custody and the way that this is dealt with. So, in terms of digital evidence, we're guided by the ISO standard in that regard. And the ISO standard is 27037, which governs the appropriate paths and steps for acquisition of digital evidence and digital investigations. Now, in terms of standards, there are particular requirements that need to be met for the acquisition of digital exhibits. So if I quote from the standard itself, potential digital evidence must be collected in such a manner that its integrity is preserved. It's common practice to make verifiable images. And preservation of the integrity of the evidence and chain of custody is of the utmost importance during the process. Care should also be taken not to damage the media containing potential evidence due to shock, temperature, humidity, pollution, loss of power, malfunction, etc. From the time the exhibit is acquired, it must be kept in a reasonable and responsible manner, not just thrown in a drawer somewhere. So in summary, the key elements are acquisition, custody, and finally analysis in a reproducible manner. Now, acquisition refers to identification of something as an exhibit and creating a mirror image of the exhibit if necessary. That would be acquiring it for analysis. And it's absolutely pivotal that during the acquisition of evidence, the process takes place cautiously and with the appropriate authority. No change to the media should ever take place at all, and a number of write blocking solutions are available for that purpose. So write blocking of a hard drive, write blocking of a USB drive before it's assessed, before it's imaged, same with the cellular phone. And as much as for any regular piece of evidence, digital evidence needs to be treated with the same deference. So it's important that cellular devices, for example, are put into flight mode and preferably inside a Faraday bag, which prevents the device from receiving any inbound Bluetooth, Wi-Fi, or cellular connections that could cause data to be removed from the device remotely. Now, who can acquire? Well, effectively, at this point in time, an investigator can acquire an object, consider it to be evidence, and place it into a chain of custody. Obviously, he's going to have to substantiate that with a written statement and in court as to what his qualification to do so is, to substantiate that he is appropriately trained in chain of custody, imaging if he's done any imaging, and he's going to have to provide you with a chain of custody statement, which declares why he considered the item to be an exhibit, on what authority is he acting. It's going to have the seal numbers of the tamper-proof bags that have been used, and there the standard is one device to one bag. I've seen a number of cases where 3 or 4 cell phones belonging to different people are put into one bag with a laptop. Now, I, as a forensic investigator, understand the circumstances and not always having all the gear the guys need, but the standard should be one device, one bag. What if you're exercising an Anton pillar and you now place those devices in the custody of the sheriff, and the court hears the respondent's side of the story and decides, okay, only one of the cell phones may be inspected, the other devices must all be returned. Well, they're all tagged and bagged together. Now you're going to have to unbag all of them under supervision to only remove the one device, to hand that for analysis, and then seal and return the others. It all becomes a little bit clumsy, and it can lead to mistakes in the paperwork. I've seen plenty of cases where I've picked up the tamper-proof bag and the serial number of the device that should be in it does not correlate to the device that's inside. That device is in another bag, and in the process of acquiring it, they've got it all muddled up. Now, if I'm engaged as an expert, I would have to question, if you can't get simple chain of custody right, do I need to be worried about your analysis? It's a fundamental argument. So it's always something that you undertake slowly, meticulously, and triple check that the paperwork is correct, that the tamper-proof bag numbers are correct, that the serial numbers correlate, that the equipment inside those bags correlate, that the master control sheet lists all of the items conclusively, that all of the paper trail is correct and presented to you as the attorney. So, for example, let's take a civil case. If you have handed a hard drive into a lab for analysis so that you can now investigate and understand what's on that drive as part of your case, you should, when you receive the drive back from the lab, receive the chain of custody documents showing from the point it was handed in all the way through to the return to you, so that you can then in turn preserve that chain of custody moving forward. It's vital that you're able to show in court that there's been no outside access or impeded access to that device during the time it's been in custody. Custody, principles of safe custody. Well, it's really quite straightforward. It's all about control. Any digital exhibit should be sealed in a tamper-proof bag with a serial number and the serial number properly recorded. The movement and custody of the exhibit should be well documented, and it should be provided with any analysis reports or the return of the exhibit. So it's important that a chain of custody bag is maintained from the time the item is identified all the way through to its disposal. Now, I'm sure you've all seen these bags. You've seen the SAPS equivalent of these bags. Even as an attorney, I would actually advise that you do have some of these bags in your office. They're not terribly expensive. You can buy them in packs of 50. But if a client is sitting in your office and wants to give you a USB drive or something that you know is going to need to be analyzed, it would always be preferable to take it, put in the sealed bag immediately in front of the client, let them sign it, and you can move it to analysis and investigation from there. It just completes the chain of custody and keeps it all nice and tidy. Okay, analysis phase. Well, the analysis of hard drives or cellular media can be conducted with a number of tools. And these tools are largely dependent on the lab that's processing the data. And it could be leading product vendors such as FTK, Encase, Magnet, Paraben. Those are just some of the players in that space. But that tool may also need to be clarified in court to explain its suitability to the task and exactly what the tool does and how it works. So you want to be sure that whoever's analyzing it is properly trained to work with that tool or has sufficient experience to substantiate the experience with that tool. The operators of the software who performs that analysis is going to have to establish his credentials to perform the analysis, and this should be clearly outlined in his statement, which is attached to any report that he delivers. So if you bring me a hard drive and I analyze the hard drive, it's incumbent on me when I return the report to also expound on my qualification and why am I a suitable person to be performing that analysis. Of a hard drive. The hard drive will go to the war room, which will go to the lab. The lab will create an EO1 or a raw image file. It's one solid file, which is a complete copy of that drive, and then they're going to hash it. Now, hashing is where an algorithm where they create a unique value that authenticates that hard drive and then re-authenticates that the image that's created is identical in every possible respect and has not been changed in any manner. A simple thing like taking the hard drive and plugging it into a computer and unplugging it would change the hash value. So golden rule, no touchy-touchy. Right blocking, image. From your side as an attorney, if you apply for further particulars and you see there's an image of a hard drive in the case or a phone, you will be quite entitled to obviously ask for a copy of that to have it analyzed yourselves or to inspect that information. Normally, they're going to give you a single file on a drive or thumb drive if it's small, and now you sit with a file. What do you do with it? Well, you're going to have it analyzed more than likely by an expert. Now, in order to analyze the drive, what we need are an understanding of the case, what elements are you looking to, what date ranges are important, and most importantly, what keywords. Let's just put it into context. If I take a standard drive that passes through our lab, it's not uncommon to analyze the drive and find you have 250 to 300,000 emails. That would still be considered small. It's a lot of email to try and read through one by one. But the nature of the software and the reason that we use it is it can scan really fast for a keyword. So if I put the keyword Apple into the software I use, it's going to analyze the entire drive at a Boolean level for that word. In simple terms, if it's scanning the drive, it will look at the word Apple in the name of the file. But it's also going to inspect the metadata. Was the file perhaps created by someone called Apple or edited by someone called Apple? Is there an attachment called Apple? If there's a zip file as an attachment, what is inside that zip file? It's going to go and expand that, and it's going to look for the word Apple inside the files that have been zipped. So it's quite an exhaustive search. And it's a very quick way to pull together the information that you need to investigate the matter further or to find corroborating evidence. So the more keywords you're able to provide your expert with, and the more unique the keywords, the better the results he's going to be able to deliver to you in terms of a detailed report of the artifacts that match the keywords that will help you to support your case. So when working with an image, if you're going to process it out to a lab for analysis, always try to give them as many unique keywords as possible. They can be company names, they can be people's names, people's phone numbers, people's ID numbers. Help them to give you the best result possible. One of the important parts of analysis that takes place on a drive is, of course, the analysis of registry artifacts. Now, the registry is basically the brain. It's the brain of the Windows operating system. And it's absolutely invaluable in establishing which user was logged onto a computer at a specific time, which IP address was assigned, what network did they use, and what was the pattern of user behavior. Where we deal, for example, with pornography cases, it's vital to be able to put the person behind the keyboard. Certainly, the artifacts may show that pornography was served or engaged in over that computer on Monday, the 3rd of January, between 4 o'clock and 5 o'clock. But can I place the owner of that laptop or the suspect behind the laptop? How do I know it's him? I need to find corroborating data that shows it's him. Equally, I need to show that the pornography is not the result of malware that's infected the machine and is just randomly throwing up and popping up porn windows. Did the person intentionally type the address into the URL bar? Did they click on a link that could have been innocuous in appearance, but then took them to a pornography website, which in turn spawned other windows? Was it intentional or unintentional? Those artifacts typically lie within the registry and can be picked apart to enormous value in employee conduct investigations, fraud investigations, pornography, luring. There's a wide variety of areas where we're going to be using those. Again, the more that your forensic investigator understands about the case and what you're trying to prove and achieve, the more data he can give you. The more narrow the date ranges you can give him to work with, the more likely he is to find solid supporting information. So let's talk about extracting data out of cell phones in general, not just WhatsApp. But what is there and what can you get? Well, in an ideal world, the best way by which to produce any form of cellular evidence remains a physical dump of the phone. But within the industry, we have a few geeky terms that are worth noting just to understand what they are and what they're not. The first being a dump. So a cellular acquisition is divided into two forms, a physical dump and a logical dump. A physical dump refers to the entire contents of the storage of the phone, including any remnants of deleted items. Whereas a logical dump refers to the current content of the storage of the phone. And it could include a few deleted items that are considered low-hanging fruit, recently deleted, but it will bear limited results in finding deleted data. Whether your case requires a logical or a physical dump of the phone is largely dependent on the case itself and its requirements. In most instances, a logical dump will do. But if you can, go for physical. Rather too much data than too little. The standard within the industry, and I must stress here, I am generally vendor agnostic. I don't like being bound to any particular vendor or tool. However, I have to concede that Cellebrite remains the industry leader by far and away. And it is the most broadly used tool in South Africa for dumps. As a forensic investigator, I like to work with hands-on tools and do things myself. Cellebrite, though, is convenient, and it's pretty hard to better the performance and the abilities of this device, which is obviously why it's so widely used by SAPS, the Hawks, most of the state departments, SARS, and commercially as well. So broadly speaking, Cellebrite's able to do all the wizardry that you need, from removing a password off a phone, removing a swipe code, to acquiring deleted data, WhatsApp databases, pretty much every scrap of data that's available from a phone. If Cellebrite can't get it, you're not going to. Now, Cellebrite will always output its data as a UFED file. That is the proprietary format that Cellebrite works in. And a UFED file can be read by any computer as long as it's provided with the reader software. If you look at the snapshot over there, the slide, you're going to see a snapshot of Cellebrite reader software. And on the left-hand side, you can work through the phone in a logical sequence, reviewing the images, the messages, the contacts, and even the timeline of the functionality of the handset. Oh, pardon me. Now, Cellebrite, of course, is not the most economical device on the market. As a rough guideline, please, this is just a rough guideline. A physical dump of a smartphone would cost between 4,000 and 5,000 Rand. It'll take about 48 hours to complete. There are other tools on the market that can achieve really excellent investigative results, but there are a few that will parallel Cellebrite for tried and tested forensic level results. Were you working with criminal matters where SAPS has created the dump file of a phone? It will inevitably be in the UFED format for Cellebrite. The files can be rather big, and you're normally going to have to provide an external hard drive rather than a USB drive for them to place it onto. So let's have a quick look at the primary screen of Cellebrite when you open the UFED file, and you'll see that it authenticates the device that was inspected, the date it was analyzed, and it provides you the IMEI number, and if there's SIM card present, the IMSI number of the phone. You'll see all that data is over here so that you can verify the correct phone as it belongs to your client was in fact analyzed. Now, as you delve into the file itself, you notice that everything's really neatly accessible from the menu on the left. Below the SMS messages, typically where you find WhatsApp messages that are catalogued in conversation order. Call logs, which are quite pivotal in many investigations, will also be included inbound, outbound, and missed calls. So unanswered outbound calls, missed calls should also be in this listing. Working through the menu on the left, you can also access the photographs taken on the device. You can see the metadata of the photographs, as well as the deleted items, which it will refer to as carved items. Finally, you'll be able to see a timeline view. The timeline view will show you all of the actions that have taken place on the device in date order. The date, of course, is taken from the device. And this can be quite critical where you're wanting to put together a sequence of events and sketch out the timeline of who communicated with whom, when, and how. You'll also be able to find on the more advanced smartphones, you'll find the Wi-Fi access points. Which Wi-Fi access points has this phone attached to? If you're looking at something like an Apple iPhone, you'll also see the GPS waypoints that have followed the phone around. Sometimes you can find that on the Android device as well. And you'll get a view of the movement of that cell phone. So whenever you see in your case that SAPS has created a UFED file or a phone that you have could have pivotal evidence to an investigation, this is a type of output and result that you are looking for in order to further your investigation and to build your case and show an evidentiary trail. Just one final thing over here on the left-hand side, hopefully you can see that. On the left, you'll see it says report, extraction summary, and you can see that this was a logical dump, not physical. So you will see immediately if it was the whole contents of the phone or just what was on the phone at that point in time. Right, moving along to away from cell phones and to something that's equally important these days and kind of topical. The presentation of online evidence. Do not believe everything you read on social media. Abraham Lincoln, 1853. Typical social media quote, that one. Well, obviously that isn't an honest aim quote, but it's still pretty accurate. And as you know, social media can be a treasure trove of usable evidence in a lot of cases. It can be used to support motive, to establish relationships, to establish where people were at particular times, who was at a particular event, to estimate the standard of living. There are very few limitations to the way in that social media data cannot be used. But the question, of course, is, will it stand up in court? And too often I see cases where social media data is presented as a really key part of a case. This is usually in civil matters. And the data is evidenced by nothing more than a screenshot. Now, a screenshot is really, really poor evidentiary value. A screenshot can be manipulated, and with popular editing tools like Adobe Photoshop or Corel Draw, it's really so simple that it can be very difficult to tell a genuine screenshot from one that's been manipulated. That becomes absolutely critical where the original post has been deleted and is no longer visible. You cannot find it anymore. And all you have left is that screenshot. Can you go into court confidently and present a screenshot and paste it into a Word document or something? Is it going to stand up to scrutiny? Is it possible that it was edited? It's pretty tricky territory. So capturing social media data is really, really pivotal in being able to present it confidently when it gets to court. At its most basic level, one needs to understand the difference between a vanity name and a user account. Now, earlier on with WhatsApp, I briefly mentioned the difference between a user account and a vanity name. And again, on social media, it continues. So in the image on the screen, you'll see that the account over here is in my name, but that is a vanity name. So should I, for example, have posted something contentious and I see trouble brewing, I could simply go to settings and change my vanity name to Bob Smith. Then you're really going to struggle to find my original post or tie it back to me. If, however, you have my user account name, it becomes just a little bit harder to hide away. It's not impossible, but it becomes much easier to track. If you look over here, you'll see that while my screen name is Craig Pedersen with an O-N, my user account name spells my surname correctly. And my user account name is Craig Pedersen SA. If you get geeky and you delve into the source code, you'll actually find a numeric value, which is what Facebook understands my account name to be, and it is unique. Instagram, Twitter, most of the popular social media strands have the same ability to hold a different account name from your vanity name. Same with Instagram. If you look at this example, you'll see that the profile name is Alex Duncan, yet the registered user account name in the top left is Greg Pierce. So clearly the account is either fake or it's been disguised for some reason. So when the account was registered, it began at Greg Pierce, and it was later changed to Alex Duncan. If I wanted to find posts by the original Greg Pierce, I couldn't. I couldn't look for him. He no longer exists. He's now called Alex Duncan. I would have to have the full username or user code in order to see the metamorphosis to Alex Duncan and still go back and find that post. By the time the information reaches you in the form of an instruction from a client, the data could already have been deleted or changed. So it's really important to acquire that username over there in the URL bar as quickly as possible, and make sure that it's retained so that you can go back and search if this profile is deactivated, deleted, or if the profile itself is suddenly renamed. If you're going to subpoena Facebook for data in and around this profile, don't make your subpoena to Facebook for the profile of Alex Duncan. They really don't care, and they will reject it immediately. You have to request by the user code or the actual user account number and the date on which the user account number was last in use. So very important in having that data correct when you're going to investigate, but also when you're going to prepare a subpoena and when you're going to capture it in an appropriate manner for court. So bearing in mind how easily a screenshot can be manipulated and vanity names can be changed, how do you acquire social media and online content in a manner that would be acceptable to a court? Well, I'm going to show you one tool, but I'm going to tell you about a couple. I have no actual association or make any money from them, etc. It's just a tool of preference that we use in our practice that works for us. Tomoko Discovery is an evidentiary capture tool. Now, there are free ones that you can use. Examples of two would be Periscope or Hunchly, but today they're much the same. I'm just going to run you quickly through Tomoko and how it works. So Tomoko has two components to it. It's not very expensive. It's a few $100 a month. The online case management on the website, which is the first slide you're seeing over here, allows you to create all of your cases, store them by investigator, and within each case will be the evidentiary artifacts that you need. The second part is the actual capture tool. Capture tool is a small program that you download onto your computer, and it's got a built-in version of Google Chrome that you use for capturing online artifacts. So just like normal, you'd go into Tomoko Capture, you'd open the Chrome interface, and you would navigate to the Facebook account, the Twitter account, the IOL page, the blog page, wherever you want to go. And in the top corner, you'll see there's a little camera icon. You click on the camera icon, and it will ask you which case is this for. You designate the case it's for, and the server, which is somewhere on the other end of the world in Canada, will create the screenshot for you on your behalf. It is third party. At the same time, it will create an MD5 hash to authenticate that screenshot and substantiate that it was taken of that page. That is what that page looked like at that date, at that time. It is auditable. It can be replicated Your opponent can go forth and investigate, and they can go and check the URL themselves, and they will have to concur that that is correct. So it's an impartial screen capture tool. Unlike a rather questionable screenshot that's slapped, copied and pasted into Word and printed, Tomoka delivers a forensically sound screen capture that will withstand a challenge in court. Even when the original page has been altered, redacted, or even deleted, at least you have it captured correctly. I would really strongly encourage you to use some form of evidentiary capture software when you're working with social media and online information to make sure that it stands up to scrutiny in court and avoid situations where the data has been changed or deleted after the fact. And I'm just about on time. So, in summary, we've discussed WhatsApp as a tool, as a source of evidence, the way in which it's presented, the way that you can subpoena it in a criminal matter if you need to. We've looked at ways that WhatsApp can be extracted and supported as evidence. It's not a forensic process, but it can be extracted and reported in that way and substantiated in the absence of a dump file. Then we've discussed the chain of custody, the analysis of cellular device, what you can expect to receive and how you would work with that. And then, of course, we moved through to the presentation of social media and online evidence in court by using an evidentiary capture tool. Please, again, Tomoka is just one of the tools that we use. Periscope and Hunchley are equally good tools. I am going to put these links for you into the chat area if anybody's interested and wants to go and look at some of the tools I've discussed and how we've used them today. The ISO standards that I mentioned, I'm going to put some links into those as well. And I really hope, 45 minutes, an hour, it's a really short session to try and brain dump as much information as possible. But I do hope at least you have one or two takeaways from today's session that will help build your understanding and help improve your abilities and your capabilities and your understanding of what can be done and the value of utilizing forensics within your cases. And I'm going to stop sharing my screen over there so I can just hop back into the session. And I'm going to just take the links that were discussed and I'm going to pop them over here for you. I didn't want to be too...
Your screen, sorry to interrupt. You seem to be a bit...
am I back?
Getting there. Not all of there we are.
Okay.
Perfect. We can see you.
See, I promise.
Straight in the eye now.
I have the perfect face for radio. Okay. I've pasted a couple of links into the chat area for you that will hopefully help you a little bit. I'm quite sure you guys all understand what an MLAT is and how it works, but just in case you want a bit of more background, there is a link to the Mutual Legal Assistance Treaty, how it works for criminal and civil process. There's some links to the NIST standard on digital evidence handling, which is a global standard that South Africa tries to sort of follow as closely as possible. In case the SAPS investigating officer that you work with has never subpoenaed WhatsApp or never subpoenaed Facebook, it's quite common. Very few of the investigating officers have actually done it. Just to make it easier, I've pasted in the actual login credentials to both the WhatsApp and Facebook law enforcement portals so that you can provide the IO with it if they don't have it. You won't be able to log in there yourself, but you can just give a bit of a helping hand in that regard. And finally, I've added a couple of documents in around the ECT Act, and I think on the new cybercrimes bill as well. It's something well worth reading if you're not familiar with it yet, as in it's got quite far-reaching implications on how we work with cybercrime and digital artifacts once that bill is enacted, which, please God, we have within the next couple of months. Really, it's a phenomenal piece of legislation. I would advise that you go and read through it, and I'm going to catch my breath. William, thank you very much.
Thank you, Craig. Thank you for that. And I think the point that is made, that you certainly need to do, as a lawyer, to do your research, to get the top forensic person involved. And you as a lawyer need to check the case law on with regard to certain aspects of forensic evidence. These days, so many ex-police officers are joining up and becoming so-called forensic investigators. In fact, the other day I was in court in Cape Town, and at the front of the court where the lawyers sit, there was a file indicating that somebody was a forensic investigator. And when I opened the file, and I'm not going to mention the person's name at this point, I noticed who it was. And he actually is a lawyer that has been struck off the roll for many, many years, yet he is professing to be a forensic investigator. So I think it's very important that one gets the right person. And as a lawyer, you need to know who that right person is. And I think one builds up a profile of various investigators, depending on what you need, if it's fingerprints, if it's footprints, if it's dental records, if it's CCTV footage, and if it's all the digital stuff that you've dealt with. Now, what I've done is also I've put out a number of articles under the topic forensic evidence. I believe the delegates have all received those. They've been emailed to them. But basically, if one goes and has a look at that desktop, then one, let's just get that off, under forensic evidence as a heading, you will see their discussion points, and I've attached some articles. The first one deals with fingerprint evidence. Then we have the uncertainty and the issue with regard to data messages. If it's not original, it is inadmissible. That, I think, Craig, links up with your chat. Then we've got an article dealing with time of death. Now, this is obviously very important with regard to when somebody has died. So where a pathologist has indicated the time of death as being 1 o'clock in the morning, and the accused in the matter, who may have been married to the deceased, and the allegation is, well, at 1 o'clock in the morning, he was at home. Therefore, he had to have caused the death of the deceased. However, his defense is he had, in fact, left the home at 11:30. So it is extremely important to be able to assess what is the time of death. For that, you need to engage a forensic pathologist. The most of the pathologists that testify in court are those called by the state. So one has to go out and try and look at somebody who forensically is prepared to testify as to something like the cause of death. Or it could have been relating to the time of death, or it could have been relating to any issue around why the person has died, if that is your client's defense. Obviously, you don't need to spend days on your client's defense if he says he wasn't there at all, and it becomes a question of identification. Then cause of death is not necessarily important to your client's version of events. Chain of custody, how to ensure digital evidence stands up in court. Craig has dealt with this. I'm not going to be dealing with it in any great detail. These are just articles that I believe are important for legal practitioners to read. Chain of custody is absolutely vital. I'm aware of cases, for example, where a ballistics evidence, the casings of bullets were taken from the scene of a crime, and they were placed in a forensic bag, as Craig referred to. But at some point, that forensic bag was cut open before the forensic analysis was done of the casings. So that immediately creates a serious dent in the custody chain of the state. So one has to be pretty much on top of your game. You need to check the forensic statements. You need to check the chain of evidence statements. In drink and drive cases, obviously, it's crucial. The chain of evidence from the time the blood sample is taken, or rather the blood vial is taken, to the nurse who draws the blood, and the nurse to whoever, and all the way along to when it ends up in the forensic laboratory for analysis. A case can be dismissed purely on the fact that there is a breach in the chain of the forensic evidence. So it's very important when one looks at your further particulars, the evidence that you receive from the state, is to scrutinize the evidence properly and check on the chain. Just as important in a drink and drive case is the time. In other words, the 2-hour limit. So the time the vehicle is stopped to the time the blood is drawn. If that is 1 split second more than 2 hours, then it's immaterial as to what the forensic report says as to the blood level. Here is also an article by Meintjes van der Walt on fingerprint evidence. So often it becomes crucial in a case whether or not somebody's fingerprints are found, and how many legal practitioners can effectively cross-examine a fingerprint expert. That is why it's so important to engage your own expert. And it is a question of cost, but I'm sure one can sort that out with the expert, just to get that basic information to be able to cross-examine, because it becomes very technical. As you've heard from Craig, the evidence is of a technical nature, and many magistrates and judges do not understand the technical aspect of evidence. That is why it's so important that when you engage a forensic expert, or any expert for that matter, that it is crucial that it is the right person, because the court has to rely on that person's input and inferences. And if at the end of the day it's been rejected, then it becomes a huge problem. Now, if one looks at a pending case, the matter of the accused Jason Roode, which is still pending, he was convicted, sentenced, leave to appeal has been granted, bail was granted, but the matter hasn't been concluded. In that case, the state called various forensic evidence, witnesses, the defense called as well. So out of all of that, the court has to make a finding, who to believe and who not to believe. The end also, the state has got to prove its case beyond a reasonable doubt. So the article that I've also attached in the bundle of articles, right at the end, is one by Henry Laram, dealing with beware the hired gun. Are expert witnesses unbiased? And it's interesting to go all the way back to cases emanating from 1873, looking at the fact that an expert must be unbiased. And courts can convict purely on the opinion of an expert witness. And sometimes, historically, those witnesses later on have found to be wanting. I mean, if you look at the United States of America, where so many cases were set aside relating to DNA evidence, where people were convicted based on, let's say, an expert's testimony in court. Later on, the DNA, which then became more prominent, established that that person was in fact not guilty of the offense. And some of those accused were actually languishing on death row. So it becomes quite scary where the courts can rely on certain witnesses and draw inferences and say, well, that witness is truthful. So it's important to go and investigate the opposition, whether it's a criminal or civil matter, the opposition expert witnesses, to go and establish their expertise. What is, where do they come from? How did they get to that opinion? Based on what? To be able to effectively cross-examine that witness. So if you've got your own experts, they must give you that information. And it may be established that that expert witness's evidence in previous cases has been regarded as totally unreliable. And then you need that information. You need that background. There's also an article, if it's not original, it is inadmissible, as we've dealt with. So those are basically the articles that I have referred to. And right at the end of the bundle, you will see the article by Henry Laram dealing with the issue of expert witnesses and you know, how to brief a witness, give them the facts, give them the docket, allow that witness to go and digest the evidence, and then come to you with a report. And obviously, you don't have to use the report, but you can't go and tell the witness, hang on, I don't like what you say. So you must, if you're going to call that witness, then you must be aware that if it's a witness coming to testify about an aspect that you as the defense counsel are not happy with, maybe rather not call that witness. And don't tell your opponent, the prosecutor, because he might say, well, hang on, I'm going to call that witness because that expert witness says things that are detrimental to the defense's case. It is a topic that we can discuss for days. And as I said in the beginning, it's a topic that needs to form part of your practice. In fact, it has to form part of your education initially. And I think that is where we need to engage universities to become more involved with presenting to students how crucial knowledge of forensics are where you haven't studied it. You may know nothing about maths and science as a lawyer during your studies. You may know nothing about engineering aspects, but that might become a very crucial part of your case. And very important, and it's a topic I've alluded to, is inspections. Go and have an inspection with a witness at the crime scene and try and engage that expert early on in the case. Now, unfortunately, when an accused is arrested, you as defense counsel have to wait before you can get the evidence. And that wait could be 2 or 3 months. By then, it might be too late. If it relates to, let's say, cause of death, and you need your forensic pathologist to go and examine the body might have been placed into the earth. It might have been transferred overseas. It's disappeared. You can't then go and investigate the cause of death by trying to have your expert examine the body. However, if you're smart enough, you can bring an interlocutory application even before you get the evidence to say, well, I want the body not to be handed over. I want it to remain at the state mortuary. I want it there until I obtain the forensic pathologist's report, and then I want to engage my own forensic pathologist. That is if you have a good reason to believe that that there is a problem with regard to the way the person died and the cause of death, which affects or could affect your client's defense on the case. I think that wraps up forensic evidence as far as this discussion group is concerned. I think it's probably best to take a short break. We already, we started late, and we have to try and end off by 12:30, and there are a few other topics. So if possibly we can have, let's say, a 10 minutes break, come back, and if there are questions, we can spend, say, five or 10 minutes chatting about those questions. Are you okay with that, Craig? You've got sufficient time to answer some questions.
100%.
Okay. All right. Perfect. So let's get back in about 5 or so minutes time. Make it 10 minutes so everybody can have a proper stretch legs and a break. Thank you. Barbara, hi, I thought I'd just give you a shot. Look, I know we started a bit late, so we're going to be running out of a bit of time to finish at 12:30. But I think, the most important part is actually the forensic side of things. And if that's okay with you, and then, I'll deal with the other topics, that we've set out. Is that fine? Because you want to finish at 12:30, don't you?
Hi, Mr. Booth. She stepped out, but
okay.
if it's Amo, if you can,
okay.
we can. If you can, we can push it. Whether you can still push for the next 30 minutes, if that's okay with you, we are more than happy to do that.
Okay, so I think what we do is we'll just have I see Barbara's. Are you calling me? Barbara's calling.
Yeah, it was Barbara calling you. Here she is.
No, he called me.
Okay, I'll phone you on the phone. Hang on, I'll put it on mute. Hi, everybody. Everybody back from wherever they've gone. Craig, you're back online. Can we hear each other?
I'm back.
Okay.
Thank you, William.
Have you seen any questions coming through?
Okay, I have question from Andrea Maria. Who can be held liable for defamatory WhatsApp messages? For example, the receiver receives a message that is defamatory. The owner of the sender mobile phone denies sending the message. It's actually quite an interesting question in that I've done a number of these cases where people have received rather short curtain derogatory messages just out of the blue. There's seemingly no justification. It just arrives there, and sometimes it's even pornographic in nature. And although it comes from that specific WhatsApp account number, when you dig into it, you can find that it's inadvertent. It hasn't been sent intentionally. The person has some form of malware on their device, and that is spawning the message. The onus, however, to my understanding, would remain on the sender of the message to show that the content was not theirs and that they did not send it. It is possible to spoof WhatsApp messaging to a degree and make it appear as though somebody else has sent it. Question from Renee. Would I recommend the Would I recommend the Udemy OSINT course? Renee, difficult. I've actually looked at the Udemy OSINT one before. You know, it's not bad for what it costs, but you do get what you pay for. It is fairly light in terms of the structure and content of what it provides. But to take it as a further step of learning, I don't think it's a particularly expensive course. Yeah, I would do it. I mean, you've got to learn a couple of good skills in there that can certainly be used. Another one from Andre. Are there capture software tools that can be used for WhatsApp? On device, that you can use on the device, no. Although I have seen it done, you could use Tomoko capture for that. You could log into WhatsApp web, I suppose, and do screen capture from there. That would probably work as well. But again, I just take photographs. I would extract the text file and hash it just to be on the safe side as well. I'm actually just going to pop a link into the chat as well. Over here, there's a very good program run by the University of Pretoria. Professor Hannes Jordan, I think, runs that. And it's a post-grad type course which covers digital forensics as a discipline. Now, it's not obviously exhaustive in what it covers, you know, there's time constraints, but he actually does a really, really good job of delving into the different skill sets that separate forensics, digital forensics as a discipline. And I would say in terms of value for money for legal practitioners, you do very well to attend that because you'll get a very good top-level understanding of the processes, the protocols, the standards, and how it's supposed to be done, which would in turn assist you from a criminal defense point of view to understand whether what you've been given has been correctly done and dealt with. Can a question from Andres Engelbrecht, can video taken on the cell phone be tampered with or changed? Yes, absolutely it can. It can indeed. Typical video on a cell phone would be shot at about 15 to 20 frames per second. So you could make minute changes in the file. You could edit the file and put it back again. I'd prefer to dump the phone and then extract the video natively from the dump. And then I'd still want to authenticate that video through another software application that we use to make sure there are no missing frames or metadata, that it hasn't actually been tampered with in any way, because yes, it can be. Renee.
Sorry, Craig, I see there's the effect on a Section 205 subpoena. Does POPI have an effect on Section 205 subpoena? Do you want to it from Estelle? A bit higher up in the questions.
Estelle Feltzman. Ooh, okay, tricky questions. I actually haven't addressed that one before, but it would have an influence in general. I'll go back to the example of a WhatsApp conversation. Is perhaps not a good one, because WhatsApp doesn't store very much. Better example would be Gmail, because you can, of course, subpoena Gmail under MLAT as well. If you're going to write a subpoena to Gmail and it revolves around the conversations between party A and party B, you have to be totally explicit and narrow in your request. If you request anything that could be party C, let's say, for example, you ask them for all the email correspondence of party B, you are not going to get it. They're going to come back to you with the equivalent of POPI and say, not a chance, will breach the privacy and confidentiality of that person, and third parties unknown. If you specifically say, I want the correspondence between party A and party B, and this is the relevance and how it's going to be used in my case, you will probably get it. If there's a third party that you're aware of that is CC'd into that correspondence, you would do well to mention that in your subpoena as well, and just note that they are there and you're aware of it. Otherwise, it could well get kicked back. Compliance is quite an issue, and none of the service providers will give you any data that's going to impede the rights of the third party. Renee, I've seen a number of people claiming that social media accounts have been hacked and the connections might have received unsavory messages. How can they prove that they've been hacked? Okay, generally that comes, it's got a starting point to it. And the starting point is you'll find that they've added a new friend that is out of pattern to their other friends, and that profile is a rogue profile and has somehow got them to click on a link. You can also find that it's one of these stupid apps that they download, Find the Ferret or Trivial Pursuit 2014, some innocuous little app, and they don't realize the amount of permissions that they're giving to the application in the process. So as long as they haven't too much tampering on the side of their Facebook profile after it's discovered, yes, you could probably find the tracks of it and you could find what's responsible for sending it. I've had one matter where I dealt with where a school-going youngster was actually disciplined and expelled from the school on the basis of Instagram messages that he'd sent to a girl in a class. When we delved into it, we actually found that it wasn't him at all. He didn't ever have his phone with him at the time. It was automated, and it was done by a social media hijack of his Instagram account. And we could actually show that the Instagram account was no longer under his control and was being run outside of South Africa completely. It did take a little while to stitch it together, but we were able to give clarity to the child and get him reinstated at school, and give clarity to the girl's parents that she wasn't being subjected to stalking by a child within the school. It was one of these syndicated type things that happens outside of the country. Would POPI apply to an app? Yes, it would. POPI applies to pretty much everything, internal and external. TikTok, however, is pretty much a little law to itself. Not one of my favorite applications. You will never see me doing a TikTok anything. I will not allow my children to do TikTok anything. I will not allow them near the app as all. It is far too leaky. It's far too dubious in terms of how the data is worked with and where the data goes and what the data is actually used for. Could you enforce POPI compliance on a Chinese company? I'd be pretty impressed if you could. The Chinese are not really renowned for cooperation. I think that's going to be quite an issue. I don't think you're going to get POPI compliance out of them. We could try it, but I very much doubt it.
I think possibly also you have any other international company that may post a post on social media to try and get that removed. And if the company refuses, you'd have to obviously go and try and get a court order, and it may be a bit more problematic if the company is a Chinese or United States based company. So I think it's because a lot of your social media sites, and this is the big problem, place or allow comments to be placed on their sites without investigating the truthfulness of it. So, it's the same as, let's just take a newspaper. If a newspaper just reports whatever anybody says without checking up on the credentials of that person and, the veracity of the story, they could civilly be held liable. So, if somebody starts making threatening messages on social media and you're going to block them, and the company running, whoever may be the company, let's say TikTok, whatever, registered in another country, are they going to comply, even if it's a court order from South Africa? So it raises very, very interesting debate, because so much is said on social media which may be untruthful and seriously defamatory, more and more so these days. We need to just end off the forensic section, because we're going to run out of time. We are looking at finishing at 1 o'clock, although we were scheduled for 12:30. So are there a few other questions, Craig, that you feel you want to address?
The safe harbor clause there, Renee, I actually would have to do a bit of research. I'm not sure if it would be applicable. I would assume so, but I'd have to do some research. I will pop you a message later on LinkedIn, because we're connected there. Give me a little bit of time. Let me just have a look at that. I don't want to venture a guess. William, I'm going to close off from my side, sir. Thank you very much for having me today.
Thank you for joining us. Thank you very much.
To the next one.
Absolutely. Tomorrow.
Yep.
Thanks.
Same time and place.
I'm happy if you leave us, and then we will chat again at the second seminar tomorrow. Thanks, Craig. Cheers.
Thanks so much, William. Cheers.